Yes, Ms. Rees.
Thank you. May I pick up from a point we discussed just before the lunch and adjournment? It was the matter of witnesses speaking to the police officer. I have found two references for you that might elicit and make it more clear that Officer Sutton had spoken to three of the witnesses. The first reference is EB 109, right at the top of the page, at number 5. I arrested and charged Nardis Maynard on the information of Jason Hamilton. So he clearly did speak to Jason Hamilton. And we know that the date that Nardis was arrested. And if we go over to 110, and we go up to line 10, EB 1110, when I made the arrest of Nardis Maynard, I'd spoken to Miss Powell and Miss Lowry.
So that's...
Well, that's different from what he spoke to them after.
Well,
had been arrested.
That's the reason why I thought I would draw that to your attention. When I made the arrest, I had spoken to Powell and Lowry. If I may now move to the second important identification recognition witness, Miss Powell. I will take it in the same fashion that I have done before. If we go to EB 87, we will see there that that's the beginning of her account. And of importance, if we look at the time, the time is common to both. After midnight to 1 a.m., and she makes that clear. I was at home between midnight and 1 o'clock in the morning. That's within the first paragraph on E-bundle 87. So that's the timing. My mother and sister are at home. She is at her table having a snack. She hears the sister yell, and she rushes to her mother's bedroom window. And she looked out of that window. She saw two accused. And here we say is an important passage onto the page of 88. It's worth just highlighting the detail that she has given in this account on page 88. I'm going to deal with it potentially the way it's set out, as it were. She refers to, excuse me, Marple. Now, Marple is Ingalls Rawlins. That's his nickname. Nardis approached a short Rasta guy and Marpo, holding Nardis, telling him to chill out. Nardis wrangled away. Marpo appeared to be off balance at the time. He became balanced. Nardis was still advancing towards the Rasta guy. By the time Marpo tried to hold him, again he swung towards the Rasta man with a knife. So she is watching in motion this altercation and the fight, and she's able to give it essentially one step at a time, as if one's winding a camera. I can tell you the length, but it seems to be wrapped in a white cloth. I can't tell you the length. He swung towards the Rasta man's chest. He swung again by the time Marpo appeared to be in shock. We will pause there. You are familiar with the pathologist's finding that there is more than one stab wound to the chest area. The accuracy of this ID witness is that she is telling you where the knife went and what part of the body. He stood watching them for about 2 minutes. That's Marpo. Then Marpo started walking backwards. Then he turned around, walked swiftly down the Market Street Road. So at the beginning of the stabbings to the chest area, the second accused walks away. But it is important to know that she's able to see that he has tried at least 2 occasions to hold off the appellant, whom she recognizes. So you have the nature of this fight and the stabbing. Someone's trying to stop him. He's absolutely adamant that the stabbing will occur. Nardis swung one more left hand to the man's lower body in his upper crotch. Surprisingly, one may say, again, the accuracy of where the knife went is exactly where the pathologist found the stab wounds in his upper groin. When he finished, he turned round, put his hand under his shirt, walked swiftly down the road. When he reached Dorset Street, he ran up the road. I was in my mother's bedroom when I saw that. Well, that clearly is the start of the fatal stabbing to the end of it. We need to know about distance, clothing, and lighting. When I saw Nardis made the swing, I was about from where I am in the witness box to the fan. It had a street light on near my mother's bedroom window. There was another light on the same side. Well, we know the mother referred to a lighting outside the bedroom window, but she says there was another one. So it gives us some idea that this area was very well lit. I am not quite sure how long I had Nardis under observation. About 15 to 20 minutes, if that long. This is clearly guesswork and an estimation. All witnesses are asked about this and they do the best they can. There was nothing blocking my vision and that night. That's very important. Clothes. Nardis had a quarter jean pant, white t-shirt, baby blue and white heady. We know she's the only witness that talks about headgear. Her mother does not mention that. Is that a criticism? It is not, we say, very firmly. People look at an event and they miss something that somebody else sees.
But is it something that the judge should highlight to the jury nonetheless?
I do. I think so.
You do think so?
I do. It's a difference.
Yeah.
When you're watching something, a jury may think, well, why didn't you see it? I'm going to come to the collection of matters that were given to the jury, because we submit that the Chief Justice was right to accept certain things should have been put to the jury, and some of those items were generous. But nonetheless, she is a judge, she was being fair, and some of it went in. The consequences of putting it in, I will perhaps just address you briefly about that.
What do you mean, put it in?
Well, sorry, she agreed with the defence that it should have been put into the judge's summing up.
Right, yes.
That was very badly said, but that's what I meant.
Okay.
I do not remember the clothes that Marpo was wearing. When Nardis was making the swing to the Rastaman said, "Mother, mother, Salsia, what stupidness you do me." So she also heard words. A policeman was on the scene. It's not possible to tell you now exactly who that police officer was. The Rastaman lay down, the ambulance came. There's a little bit more at the top of 89 that is relevant to why these witnesses together are very strong and compelling. The one I was sure that hit him was, she's talking about the stab wounds. The one I was sure that hit him was the one in the lower body part. I cannot remember how the Rasta man was dressed. I pause a little about that. It is again unusually a point of interest that this witness is emphasizing the one I'm sure got him. She wouldn't have known that the pathologist was going to rule that that is the fatal stabbing. I cannot remember how Rasta man was dressed that night. It's not a witness fabricating things. When she can't remember, she says so. When Nardis made the swing to the Rasta man, the blood started coming out. And she's again right about that, because it severed an important artery, and that's the reason for his death. That's the reason why he died. I saw Nardis swing twice to the chest area, one to the lower part of the body. 100% consistent with the finding of the blows to the upper and lower body. The cross-examination is important. This is Ingle Rawlins, a representative. She clearly took it in, what Rawlins was doing. She was able to say, when I first saw Nardis and Ingles tried to hold Nardis, and Nardis wrangled away. Ingles was pulling Nardis away from the Rasta Marpo, said, chill out, cool out, behave. I did not see Rawlins do anything to the Rasta man. I did not see Ingle Rawlins with a weapon that night. When Ingles pulled Nardis, he slipped away from him, and Ingles stumbled. His hand, Ingles' hand, touched the street. You'll recall that there were some bruises found to his hand. We don't know that he accepted he may have bruised that hand when he fell to the ground, but that's a possibility.
Well, he said he bruised it when he fell from steps, Miss Weeks. That's what was said.
Yes, I'm just referring to another place where he may have had bruises.
Right.
That's all. I can't be any more than that. He gained his balance and tried to hold him again. He was not successful in holding him. This is important to the kind of murder that happened here. You have a reasonable person trying to stop you, not once, not twice, but you're insistent, for whatever reason, to have your way. So that is the entirety of this witness.
It isn't, Miss Weeks, because she's cross-examined by Dr. Brown, and she says, I have mistaken one person for another. I'm not sure to what question that
I was going to turn to the cross-examination.
The incident happened on the opposite side of where I lived, which is different to what her mother said.
Yes, I think that's right. I should have made it clear. In chief, that was where she gave all of the details that she had. I just want to make two features about that. I will absolutely come back to the cross-examination. The very important feature to this is the detail in our respectful submission. Witnesses do the best to see what they see, but it seems to me the detail of how many times, the detail of what happened between the first accused and the second accused. She was able to deal with distance. She was able to see and even estimate one of the stab wounds that got him. That was how good her sight and her concentration was. Yes, there has been some cross-examination, and she was able to say to Ingle Rawlins what I've already set out there, I think. She was not successful in holding him. But Dr. Brown, who's the appellant, it's important. I have mistaken one person for another. I think that is, I haven't mistaken one person for another. It doesn't quite make sense. This is a challenge by the appellant's counsel. So my careful, respectful view is that sentence doesn't appear right. But those of you who wish to disagree, the incident happened on the opposite side where I lived, in the street, but more on the other side. The incident did not happen near a wall. He was perfectly right to put that there's a witness who said it was near a wall. Well, she didn't see it near a wall. She didn't accept it. She said it wasn't there, not the wall. I did not recall how Rasta man was dressed. And indeed, when you look back at this, seems to be no detail about that. The way the incident occurred, I would say Nardis was facing me when he was leaving. That's quite important, that she was able to see him facing her. I know 3 of Nardis' brothers. I don't know how many are left-handed. I don't know if any is left-handed. This is important.
There are only 3 other brothers, that's right.
Yes, that's correct. Well, certainly for her. I did not speak to any policemen the same night. Well, I made the references I did when we came back from lunch in relation to Officer Sutton. I was present when the policeman came on the scene. He spoke to a lady who came to him. I don't know who the lady was. The top of 90 is also important in relation to the value of this witness's evidence. She describes the windows, the louvres, Miami shutters. I was not in the bedroom the same time my mother was. That's an important feature if one wants to understand the difference between their accounts, because the mother sees much less than she does. Ingalls was holding on to Nardis about 2 to 3 minutes. Nardis made the first swing, maybe a minute elapsed before he made the last swing. Having made the last swing, he walked down the road swiftly. The weapon I saw was wrapped in white cloth. The cloth seemed to be the handle. I didn't see the blade. I saw the handle of the knife. I did not see the knife. Told the magistrates that I saw a knife. I spoke the truth then. I saw the handle of the knife. The most I could remember was the Rasta man had long pants. I missed out the first sentence. I saw the deceased's pants when he was being attacked. It was long. I can't say the type or colour of the pants. I was basing on Nardis' clothes. The police did not ask me to go to the police station to point out, must have been the reference, to an ID parade. It is valuable to go back to the detail and to see the difference between the mother and the daughter, and the question of whether fabrication could ever really be made out in relation to either of those important witnesses. At EB 88, I should have reminded myself to emphasize, going back to EB 88, I just want to make sure I got the right. It's 87. I'm known number 2 accused as Nardis Maynard and Daddy Screw. She has the correct name. She knows the nickname. I've known Daddy Screw practically all my life. I am 21. Those features of her knowledge of him is important. And we know that she made the reference about the brother, or the brothers, as it were. So we say that one doesn't criticise the mother for not getting as much as the daughter got. They are independent witnesses who went to the same window, but at a totally different time. They saw what they saw. There can be no question of putting their heads together, because it is clear they saw the incident. And if there's a grudge, the one thing you do want to be able to say as the mother is, I too saw him stab. That's not the case here. So the more one looks at the detail and the difference between them, the timings and what they say, this is not fabrication, and we say it is not mistaken identification. It can't be, because of the detail, because of who's involved.
Well, they could have been right about the detail and about what they saw, and that the stabs are consistent with the medical and forensic evidence, but been mistaken about the recognition evidence, that the man that they're identifying is Nardis rather than, say, Vincent or somebody else. That's the critical point, and recognition evidence can be as mistaken and witnesses can be as convinced as ordinary identification evidence. We know that now.
I absolutely understand that, and the reason for the warning that even though you think you recognise somebody, a mistake can happen, the judge did give that warning.
He did, but what about what do you say about the ground of appeal?
I'll come to that. I wanted to make this answer that valuable question. There just isn't any evidence that supports that these two females were able to watch what happened and for some reason they made a mistake. This is excellent lighting. We now have some view of the distance that they described in the court that they were in. So we have good distance. We have them, and this is important, going to the window at different times, and they see different things. This point we submit is compelling. How do you get the stab wounds in the right part of the body to the person that you're looking at, and then he turns to see, you see his face before he walks away? He hasn't made a mistake, and the mother hasn't made a mistake. We submit more likely that they'd have to fabricate it and out of some sort of grudge say it's him when it isn't. But there really isn't anything that was put to them. It should have been, so we could have understood their answer. But to say that in relation to the daughter, well, she may have been against me. Well, may is not enough if you are going to suggest that these important alibi witnesses have somehow deliberately made it up or they're mistaken.
But isn't that the point, Miss Weeks, that it's the prosecution that have to prove more than may? The defendant has to say it may be that, and if the jury think it may be that, that's a reasonable doubt. So when my lady puts to you that the fact that the witnesses, mother and daughter, may have seen the incident and not be lying about that, the point that the appellant makes is that they were certainly mistaken, whether because it was a grudge or not, about the person who was doing it.
Yeah.
And we've got all of the other evidence about a police officer going to see the mother the night before she makes her statement, which is the day or days after Daddy Screw was in custody. I mean, it doesn't take much, does it, for a conversation to occur with mother and daughter saying, do you remember seeing Daddy Screw? This is the point that Miss Gray is making, surely, that this is what the jury should have been left to consider. And it may well be that your submissions to us would have had very, very great weight with the jury. But they should have had all of it before them so that they could compare and contrast the differences and the weaknesses. That's Miss Gray's point.
Thank you. I understand the point. This decision, the decision by the Chief Justice to not allow the case to go to the jury, wasn't just on this point. It was a combination of the alibi I'm going to come to and other features.
Sorry, what, not allow the case to go to the jury?
Sorry,
What do you mean?
forgive me. Let me just put that differently. This was an appeal to the Chief Justice, and she didn't allow the appeal.
Yes.
She left
Nothing
the conviction.
To do with not letting the case
Forgive
go
me.
to the
Yeah.
jury.
So I say that one needs to look at the care and detail that she took in dealing with all of those stages before she came to her conclusion. I do accept that if it's about, did you make a mistake? If it's about, did you have a grudge or not? Generally, those are points that go to a jury. I accept that. But in the combination of these issues that were before the Chief Justice and the manner in which she dealt with them, the care that she took over each of them, applying the law as she did, she was entitled to come to the conclusion she did come to.
Well, one of the conclusions she came to was that these weaknesses weren't put before the jury, and they should have been in the perfect world, but she went on to apply the proviso. But when you say that the Chief Justice had regard to all, do you know what the Chief Justice was referring to when she referred to the other evidence that was also compelling beyond the identification?
I think there's small aspects, just a catch-all phrase, because she had dealt really
Like what?
with the most important
To what did that refer?
evidence.
Paragraph 72 of the Court of Appeals judgment.
Yeah, I can go to it just to remind myself. You know, it's difficult to second-guess what was in her mind because she didn't explain it, and I
What
accept.
was the actual evidence other than the ID evidence in this case?
It's just the other witnesses, what the police officer said and did. It's certainly the evidence from the defendant. That's important. I mean, I can't guess as to what she meant. I don't
Well, what
think...
do you invite us to consider if we're troubled about the proviso? I'm not saying we are, but if we get to that point, what would you invite us to consider
I
as
think
compelling evidence that means we can be sure there wasn't a miscarriage of justice in this?
Well, the compelling evidence for the Chief Justice is the central identification.
No. Other than paragraph 72.
I'm coming to
is
it.
The other.
The other has to be the defence evidence because that's not the central identification evidence. She may have meant that.
Or what did he say, the applicant, that could have become compelling evidence against him? His evidence was, I was at home.
It could be that she just gave a phrase that doesn't necessarily mean that she was dealing with the compulsory evidence. There wasn't anything else apart from
What do
the
you
ID.
mean by compulsory evidence?
I mean evidence that was overwhelming and very reliable.
But,
Compelling evidence.
but can
is
you
the ID.
identify any Miss Weeks?
The identification. I can't go behind the identification evidence.
So it's just the ident. You accept the reference to other is mystifying, and there wasn't any other evidence. The ID evidence was the evidence against this appellant.
I have to say, with an objective view, that was the evidence.
Yeah.
And if it's a throwaway point, it may not mean very much because this judge operated as if the identification evidence was central and compelling.
Yeah.
Well, is that fair to say it's a throwaway point after having said that she dealt with everything with so much care?
Well, might it be that the evidence given was consistent with the pathologist, for example?
That
I
is...
mean, that's not identification evidence.
No, it's not. That is a good example, and I wish I had given that answer first. But yes, I've referred to it on a number of occasions because it supports certainly Miss Powell's account of where the stab wounds were.
But that doesn't necessarily support the identification of Nardis Maynard.
No.
It supports that they gave a very accurate account of the fight that the daughter saw, and
Yes.
yeah, okay.
Part of the matters that may have affected the Chief Justice to say what she said, there was the question of the alibi and her assessment of that and her ruling about that. I am coming to deal with it. But when you deal with proviso, she was bound to consider all the aspects of evidence that was before her.
Well, how can you consider for the consideration of the application of the proviso evidence that she refused to receive?
I see it in this way. If she is dealing with the proviso, she's entitled to consider what is now not within the ring because she has rejected the application to put the fresh evidence in. So she is considering the proviso on the basis that the jury, when they considered the appellant's evidence as against the evidence given by the identification recognition witnesses, they may well have rejected it. Possibly because he didn't call alibi, but that would have been in her mind. I know that she's put it to one side and she's considering how the jury would approach it without the evidence that she has ruled that she doesn't want to take in. That's the alibi evidence because of the weaknesses within it. I've been as honest as I can. It's very difficult to judge and guess what the other evidence was. But I will say this, that should not detract from the approach that she took, which was careful, which was right, and she looked at all of the evidence very carefully. She accepted certain things should have gone to the jury through the judge's direction. But it's difficult to say why she was wrong or made an error, simply because of the stance that she has taken. And as we are dealing with the issues that were before the judge, it's difficult, and I've looked at this because I thought I may be asked, well, what did the judge do that was wrong? She may have made a comment, said something that now raises issues. Well, what are the other evidence? But her approach was correct in law. She could have been stricter about the matters that she conceded in relation to the appellant should have been given to the jury by the trial judge. But she's still within her right if she then looks at the balance of what was the overwhelming piece of evidence that was compelling, that was her word, and she was entitled to call it compelling evidence. We submit she wasn't wrong about that.
Ms. Weeks, may I just ask, you just said she could have been stricter. Could you explain what you meant by that?
About the number of things she accepted from the appellant's submissions that should have been given to the trial judge for him to remind the jury about.
Do you mean there were things that she conceded that she shouldn't have done? Is that what you're saying? Or are you saying there were other things that she should have included as
I'm
deficiencies?
just dealing with the things that she took on board. Some of them were generous.
You're saying she was generous?
Yes,
Right.
but she's entitled to be.
No, I'm not
Yeah,
criticising.
That's all we say about that.
Can I just be absolutely clear what test you think we're applying? If we get to the proviso stage, are we asking ourselves whether we would apply the proviso or whether the Court of Appeal was entitled to apply the proviso?
Whether the Court of Appeal was entitled.
That could only be if we agreed with everything the Court of Appeal had decided up to that point, couldn't it?
Yes,
Yes.
I understand.
Well, what would be helpful to me in this context, sticking for a moment with the ID evidence, which I think you're on, is if you looked at paragraph 63 of the appellant's case, where they list the matters which they say should have been specifically identified by the judge in the summing up to the jury, and say, tell us what you say about each of those matters.
I was actually coming to them, but I'm happy to come to them now. And these were the lists that were very much within page E-bundle 423. I think those are the issues
Yes,
that...
those are the ones I had in
Yes.
Yeah.
I can say straight away, some of these do not relate, we submit, in relation to identification evidence at all.
Well, you'll identify those. As you
I
go
will.
through.
There were one or two of them. Nothing was summed up to the jury about matters raised by the defence in their closing speech. And that's a specific list of matters that you can go back to within the bundle. And you can see a summary there of Dr. Brown's speech.
Well, I don't know whether it was intended to rely on more than what is then set out, which included how much of the face was covered by the head tie.
Things like that, yes.
Yes, well,
Yeah.
specifically that, I think, perhaps.
Yeah. I may have made a note of some of these.
I mean, really, all I'm asking you to say is, do you agree that that's something the judge should have drawn attention to? If you disagree with that, it would be helpful to know why.
I think we submit she went to this list in detail.
Who did?
The Chief Justice.
No, I want to know what your position is.
Oh, my position is that the matters that she took on board and
Why
accepted
don't
and
you go
agreed.
through the list and tell us what you say about each of them? That would be the really helpful thing.
Some of the matters within the closing speech, I would say...
just the face covering, just the face, how much of the face was covered by the head tie?
I can deal with that.
Yes.
This is a head tie which was not described. It wasn't described by way of length or whether it was a bandana that could have covered part of the face. There is no evidence at all that the head tie was on any part of the face.
So this was not something that the judge needed to draw to the attention.
In my personal respectful admission, I'm being asked what my personal view is.
No, your client's position, not your personal position.
Ah, right.
I
Well,
mean, what is the position of your client? What is the position you're putting forward to
well, I act for the
on this?
DPP. I act for the
Indeed,
DPP
indeed.
in St Kitts and Nevis. Because of the manner in which the headgear was described, nothing suggested that it was covering the face. Neither of the two witnesses said anything about the covering of the face, and the only witness who saw this head covering did not give a description that I could only see part of one eye or his face. So it's just a head covering. There wouldn't be any need, we would say, to have to give some sort of direction, say to the judge that ought to go to the jury.
Right.
I just need to go back because the list, which is the items mentioned, are actually within the closing speech.
I don't take the appellant to be relying on anything other than the head tie.
Okay, well, I'm happy with that. Thank you. All right.
Gray has not been, so I think we can proceed on that basis.
Thank you. The second, we can see. The jury was reminded that the appellant was left-handed like the stabber. Lowry, Powell and Handley all described the assailant as using his left hand, but the judge failed to remind the jury that Ballhead Vincent, the initial suspect, was also left-handed as testified by the female Gayton, a prosecution witness. Significantly, the jury had asked the appellant a question about his hand during his evidence, leading to his answer that he was left-handed. We submit that this is really a point for the appellant, because he may have wanted to say, well, you arrested a man who was a brother to the appellant who was also left-handed. And that should have been pursued, that should have been thought about. That is what I think this is for. But the fact of the person being left-handed wasn't a significant or a feature at all for the eyewitnesses who saw him, for the recognition.
Wasn't it that the stabber was a left-handed stabber? Wasn't that an important feature of the identification evidence?
It is an important feature, but they placed the recognition as to who they saw, undoubtedly by his face, which wasn't covered, two names that they knew and family members that they knew, and where he lived.
But they'd been told that Nardis had been arrested.
Well, one does not know any further about any details.
Well, they were told something, and we do know that Nardis was arrested.
We do not know what he was told.
No.
That's quite important. Speculation about that may not be helpful.
Ms. Weeks, you said that you agree with the judge as to the matters that should have been put to the jury, and the judge also agreed with Miss Gray that the fact that there was evidence of Vincent also being left-handed ought to have been specifically highlighted to the judge. So she seems to have found, contrary to what you're now suggesting, that this was something that should have been left to the judge.
Yes, I was simply saying not that she shouldn't have left it to the judge, but I did not see it as a central issue of the identification.
This is a very straightforward question, actually. The question I'm asking, and I think my lords and ladies are asking, is do you accept or do you not accept that this is a matter that the trial judge should have included in his summing up to the jury? That's the simple question. If you say...
Yes, I do.
You do.
I do. I simply added a view that I took of the value of it, but yes, I do.
I see. You don't... Well, the qualification is what?
The qualification is that it wasn't central.
Not central. Right.
But the judge was right to leave it as one of the lists that the judge should have put before the jury.
Yes, thank you.
By this stage, Ingle had been let off at half-time, hadn't he? The case against him had been dismissed on a submission.
Yes.
So he was in a sort of way out of the frame by the time of the summing up.
Yes.
But only in sense out of the frame somebody could safely be convicted beyond reasonable doubt, I suppose, not necessarily out of the frame as a possible alternative to the remaining defendant.
I think it was right for him to be out of the frame because of the...
Nobody's questioning that, but the relevance of him also being left-handed is...
No, he's not left-handed.
Actually, it's Vincent.
It's Vincent.
It's another brother.
It's another brother. Forgive me. Yes.
That's all right.
Yes.
It's quite easy to...
Okay, so nothing mentioned in the summing up, despite Miss Lowry stating she had observed the event for 10 to 15 minutes without any obstruction from her bedroom window. And after the stabbing, she failed to see and identify Ingalls Rawlins as being present, a man whom she knew referred only to rather than three men. This point, I recall, and I'm happy to double check, I don't think this was put in by the Chief Justice because she explained, and I will double check, that I'll just go to the page. She disagreed with it. I've got that right. Page 26. Thank you. Page 263. She gave her reasons for not putting this in. If we go to the top paragraph, and the ability of one to see Nardis and not the other is all within paragraph 60. And she went into some detail there to give an understanding of why there was a difference, and she did not, in fact, adopt that particular point.
What do you say about Miss Gray's point, which is that it's not that the judge in paragraph 60 isn't giving her reasons for saying, well, there was no reason to draw this to the jury. But Miss Gray is saying it's not what the judge thought, it's the fact that the judge should have left it to the jury. And what the judge does in paragraph 60 is, in fact, to place herself as a member of the jury, explaining away the evidence, rather than allowing that to go into the mix, so the jury could weigh everything in the balance. May have agreed, may have not agreed, but the point Miss Gray makes is it should have been before the jury.
The submission that I can properly make is this judge was looking at the overall quality of what the defence wanted and should have been put by the trial judge. And she was weighing up whether or not these matters, some of them she said were minor, would it make any difference to the jury's verdict?
So this goes to the proviso?
Yes.
Yes, but in terms of actually thinking, should it, as a matter of course, have been left to the jury, which is the first question, the proviso only becomes, as it were, a consideration once you've said, well, it should or it shouldn't, surely. She couldn't possibly say, could she, that it would have been wrong to have pointed out to the jury that there was an issue about the discrepancies between mother and daughter, and to go through those discrepancies.
We would submit that another way of looking at this is that a judge is entitled to consider the merits of a piece of evidence that she is being asked, should this not have been left to the jury? And she's entitled to look at it, assess it. And we submit that this is precisely what she was doing in paragraph 60, because it, from her point of view, would have been quite obvious. Both witnesses look at the same event. One of them doesn't see doesn't see Ingalls, Rawlins, and the other does. And she explains that. It's not unusual for different witnesses seeing and recalling scenes to which their attention is drawn differently.
But isn't it, my lady's point is, those are points the judge should have made to the jury. The jury should have been told, on the one hand, this was a fast-moving, violent incident, and different people watching such an incident may see different things. There were also timings were different. The mother saw the beginning and then the end, and the daughter saw the middle. Nonetheless, members of the jury, you may want to consider the fact that one of these women saw two people, another saw three. One of these women saw a blue head tie, the other didn't. Those are things that may affect your view, and there are other points, of the weight and the reliability of this evidence. It was for the jury to decide it, not for the judge or the Court of Appeal. That's really the point that we're asking you to address.
I've understood the point, and the only submission I can make in favour of the Chief Justice There is no fast and hard rule that whenever you come to these facts, you must always leave it to a jury. A judge must be entitled, we respectfully submit, to make a judgment call in an appeal as to what goes in and what stays out and what doesn't go to the jury. And different judges may have a different view of what should go to the jury and what shouldn't. That must be the way that the Chief Justice thought of it.
But Ms Weeks, looking at what the Chief Justice says, it's very interesting that she talks not about weaknesses in the identification evidence, but she goes to credibility. Straight away, Miss Gray contended that the credibility of Miss Lowry's evidence is impugned by her failure. And what Miss Gray was saying, surely, given the ground of appeal, was the weaknesses in the evidence seen as a whole should be put to the jury to consider credibility. Not for you, my lady, but the jury should have been left to assess credibility.
But this Chief Justice was dealing with an issue from the appellant of credibility, and not seeing one thing when another witness sees another is not about credibility.
Well,
it's about
a question of reliability, isn't it, really?
Yeah.
but not credibility.
Anyway, you basically, I think I understand your submission. It is that you support what the Chief Justice says in paragraph 60, and that is your answer to this particular
It is.
point. Yes.
On occasions, judges, respectfully, I say, should be allowed to do
It's
that.
within it was
there's
a
no
reasonable
fuss.
decision for the trial judge to take.
The head tie we dealt with under 4, unobstructed, this is number 5, despite saying she had unobstructed view of 15 to 20 minutes, referred to Rawlins as having no part to play in the
Well, I
incident.
think 4 is going to a slightly different point.
5, this is 5.
No, I think you passed over 4 because you thought it had been dealt with under 1, but actually 4 is a different point, which is that one witness saw that the assailant was wearing a head tie and the other one didn't.
And the other didn't.
That's the point.
It's my fault. I thought we dealt with it, but only one person, and that's Miss Powell, talked about having
Yes.
the head tie on it.
Should that have been drawn to the attention of the jury?
Yes,
That
I think she did. I think the Chief Justice did.
No, we're talking about the jury.
But for the jury,
trial judge.
yes.
Yes, you say that one should have been drawn to the attention of the jury. So it's a yes to that. Yes, okay.
So I can move on, if I may, to 5. Ingle Rawlins as having no part to play in the incident. Strictly, that's not correct. It's not the accurate description of to say that Ingle Rawlins was having no part. Rather, Miss Powell was saying and referring to Ingle Rawlins as not having no part to play. You'll remember that when I went back to summarise her evidence, she gave you a lot of detail about trying to stop the appellant from attacking, not once, at least twice, if not the third time, and then he walked away. Well, that is the part he played on the incident. He was trying to break it up. He was trying to stop it. So that's my only point on that. There were inconsistencies with PC Mark Handley's evidence to refer to the assailant leaving with Rawlins, a man known by Handley, as well as given evidence that Rawlins had played a part in the incident, contrary to Miss Powell's evidence. But I think I've answered it.
I mean, basically the answer there would be that Kimesha Powell wasn't looking, but that as early as PC Handley was looking. So it was PC Handley who saw both men push the victim against the fence. And I think you're saying, well, Kimesha Powell wasn't looking at that point. Is that your point there?
Miss Powell didn't see the incident right at the beginning. Her mother did. And she came later.
Yes.
But she doesn't talk about an incident where people are pushed up against.
No, well, see, that's the curiosity.
Fence.
Yes, quite. Yes, by far.
And witnesses do not have to see identically what others see. No reference in the summing up to contrasting times between length and time of the incident last and how long they'd observed each other. I have mentioned this point before. Is it better that that goes before a jury, is your question? Again, I think the Chief Justice allowed at least one or two of these examples to go before the jury. I'd have to double check.
You mean the judge?
The judge, the trial judge, the Court of Appeal judge.
The Chief Justice said that the trial judge should have mentioned this as well.
Yeah.
Should have been mentioned, yes.
7. Powell and the mother, Lowry referring to the assailant as the appellant, when the police officer Handley arrived on the scene. They each failed to provide the appellant's name and description to the police officer at the time. There's an important correction. At the scene, no officer spoke to either of these ID witnesses. There is no evidence within the transcript that any officer spoke to them. I took you to the references when Sutton spoke to them.
Wasn't Miss Gray's point that if they both saw a stabbing and both recognised the stabber, the natural thing would have been for them to go to the officer who came to their house and say, we've just witnessed a stabbing and we've recognised that the stabber was Nardis Maynard?
It's a valid point to think about, but we know that some witnesses do and others absolutely do not, particularly when they recognise who it is.
So are you saying that that's not something that the judge should have mentioned to the jury?
A judge could mention it to the jury, but it doesn't devalue that witness's account.
I think my
because they
question
haven't
is,
said a name.
should the judge in this case, what is your position on this? In this case, should the judge have mentioned it to the jury?
I'm just trying to remind myself of whether the judge in fact did.
Right, okay, fair enough.
And I just double check.
The trial judge certainly didn't.
No, he didn't. I was just simply seeing.
So basically your position is the Chief Justice was right on each of these points. You've got no independent submissions to make on that's the message I'm getting from this.
Quite a lot of them were accepted by the Chief
I know,
Justice.
but you're saying, your submission to us is that the Chief Justice was right on each of these items.
Where she
for the
said
reasons she
and
gave.
agreed with the defence, yes.
And equally the other way around.
Yes. Yeah.
So you've nothing to add to what the Chief Justice said on.
Not all of them, to be frank. I mean, we've almost got to the end of the list.
All right, well, it was quite helpful for us because it's a short way of just knowing what answer was given to each of them.
Yeah, I mean, the jury was reminded about Jason Hamilton, and this is the height issue
So where are we
here
now? Sorry.
They weren't reminded
Where are we?
of
that Jason Hamilton had made a doc ID. What they were told was he recognised Nardis Maynard as one of the two people. The jury were not told that in fact Hamilton hadn't identified Nardis Maynard originally and had made a doc ID in his
at the trial.
possession.
Definitely not. That was not.
No.
That's not a piece of evidence at the trial.
No. Well, it was a piece of evidence.
Yes, it was.
The jury were not directed about it by the judge.
I don't think anybody mentioned it within the trial as evidence, so that the judge would have known to have picked it up. I mean, that's what I consider to be the status of that. And that's something that the appellant counsel could have dealt with if they wished.
Yes, but I think that the point of an appeal, beyond attacking, in certain circumstances, the incompetence or otherwise of trial counsel, is to highlight the deficiencies of the court summing up to the jury. So to say to as well the appellant's counsel could have dealt with that isn't the same as the judge giving directions to the jury about it.
My lady, I don't know whether this piece of evidence from an earlier hearing would have been brought before the then trial judge, so he would have known. to have put it in or not. That's the point I make. It's not clear on the transcript in the trial that anybody mentioned that and used it as evidence.
Well, in the written case of the appellant at 9,
Yes.
the judge reminded the jury that Jason Hamilton had recognised Nardis Maynard as one of the two persons, yet failed to remind the jury that Hamilton had not mentioned Nardis Maynard by name in his witness statement as elicited by Ingle Rawlins, co-defending counsel in cross-examination. So it was in evidence before the jury that there had been no naming of Nardis Maynard by Mr. Hamilton beforehand. So there was evidence.
If there's evidence, it would be right for a judge to remind the jury about it.
Right, so that's a tick again.
I think that is the proper answer to be given. It would be wrong to say that the judge shouldn't remind the jury about it. The height point we have touched on, unless I need to go through that. It's perfectly a good point for a jury to be reminded about height.
Should have been reminded, yeah.
It is a form of picking out people if they happen to be of a different or whatever it was, height. The judge reminded Jason Hamilton recognised Nardis as one of the two persons, yet failed to remind the jury that Hamilton had not mentioned Nardis by name.
We've just dealt
I think
with
we've just dealt with that, thank you. Neither was the jury reminded about Jason Hamilton's evidence that his statement referred to an assailant 5'10", and that he knew the assailant's brother. Such a description, knowing the brother Eric, would have applied equally to Vincent Maynard, who was the first to be arrested after an anonymous call to the police. Again, I think this is a feature that should go to the jury. They were not reminded that Vincent Maynard's clothing was never seized during the time in custody, therefore was never scientifically tested to determine whether there was a link between his clothing and the killing. I'm fairly confident that she dealt with clothing and things that should have been tested, and that there was no scientific evidence to suggest that his clothing or that he was there at the time.
Who's they?
This is the officers who took clothing.
Yeah, sorry, yes, I'm slightly confused. We're talking here about Vincent Maynard's clothing.
We are.
So what's said here is that the jury should have been reminded that Vincent's clothing was not seized and therefore was not tested scientifically. So the question is, should the jury have been reminded of that? Yes. They should, yes.
The Court of Appeal covered quite a bit of that.
66.
Right, okay.
Yes, it did, yes. I remembered that part of that.
Right.
And then finally, the Court of Appeal 60 to 67 considered the specific weaknesses outlined, which were not mentioned during the summing up. The court accepted that some of the ID witnesses had merit, others did not. However, the essential point is that rather than look at each of these witnesses in turn, weighing them up, the court failed to recognise the summing up was devoid of specific references. Of course, the judge had to go through each of them, which she did, and a good number of them she agreed with. I don't think there's anything for me to add to that.
I mean, you're resting your case on really paragraph 67 of the Court of Appeal.
Yes, we are.
You're accepting, yes, there were deficiencies, but this ultimately takes us off to the proviso, and the identification evidence is such that it outweighs those problems.
Yes, we do, and I've set that out really shortly because the detail of it's already within the detailed judgment from the Court of Appeal. But we come back to the submission I have made. She took care in dealing with these decisions.
But I'm sorry, but I do think this is an appeal.
Yes.
This isn't a review of the decision of the Chief Justice. This is a
Second appeal.
These matters are being argued afresh before us.
And I understand that.
So, I mean, whether or not the Chief Justice addressed it with care or not, I'm sure she did. I don't think that would be an issue. But that's not really what the task for us.
In this appeal, I have accepted that there are a number of matters that should go to the trial judge so the trial judge can remind the jury about it.
Yes.
But that does not necessarily require a court to conclude, we respectfully submit, that the conviction should be set aside.
But are you agreeing that it's for us to decide that,
Absolutely.
not for us to review the Chief Justice's
Absolutely.
decision?
I agree with that. Yes, that's entirely right.
So you say a conviction was inevitable, notwithstanding.
We do say that.
Can you tell us why?
First of all, because of the quality of the identification evidence from 3 witnesses. The differences about those evidence, whether it be by time, position and site, what they see and what they don't see, is compelling because they haven't got their heads together. They are genuinely reporting what they see and what they hear. One of the witnesses, Miss Powell, is supported by her description of who it is, who the stabber is, and the finding of the medical evidence as to where the stab wounds were. So she had the person who was the stabber in her sight before any stab wound occurred, and she was able to give detail about why she recognized him. The quality, lighting, distance was very good, and a court can be confident that she is a reliable witness. There isn't any evidence of a reason why she would deliberately call his name by way of some grudge. And there is no real evidence upon which this court can say, well, here is a piece of evidence that might suggest she has made a mistake. It's really the opposite, that these 2 witnesses were able to see what they did see, and they gave their statements relatively close to the event that occurred, the early hours of the morning of Sunday, 22nd to the 23rd. So that is the summary of why one is able to accept and look at the value of the evidence. When you come to look at what the jury should have considered, the additional factual issues and differences, a court can still be in the position to be able to say, well, once we've settled everything that the jury should have before them, you are still left with the witnesses who clearly saw who it was who was responsible. I wouldn't be in the position to make this submission if there was some form of evidence to suggest that this was a mistake. one or two questions were put to the witnesses at trial. Did you make a mistake? And you can see their answers. It was not a mistake. More needs to be put to witnesses as to why they made a mistake for this court to think, well, I'm not so confident now about what those witnesses have said. So that's how we look at what is now before this court. I find it impossible to see where the mistake came into it. You can say that mistakes can happen to witnesses, but you can't just say it without some evidence and without being able to point.
No, but really what Turnbull says is that the judge must draw the jury's attention to the problems of identification evidence, both generally, which is what the judge did do in this case, and more specifically, because identification and recognition evidence is itself inherently has its problems.
Yes.
We put it that way.
Yes.
Not to follow the Turnbull approach, direction, in a wholesale way, as far as the specific items are concerned, doesn't that make it difficult to rely on the proviso? Because on what other evidence are you saying that the proviso is satisfied?
May I deal with my Lord's statement that the direction that was given by the trial judge was somehow faulty or not
Well, you've already
sufficient?
accepted it was.
But we're talking about the Turnbull direction.
Yes.
What it's deficient in is the issues of inconsistencies.
Yes, but that's part of the Turnbull direction. As my Lord said, the general warnings about ID evidence generally, and then the specific warnings about this ID evidence and why certain aspects might cause a jury to consider the reliability and the...
Well, let's look and see what is here to protect the jury. We do have the Turnbull direction in its first half. I'm going to come to the point that you have raised. There is a very good direction here about inconsistencies. It is a general...
General directions are good.
It is a
That
general
judge gave
direction.
General directions. I thought you'd conceded that so far as the specific warnings are concerned, that there were deficiencies, and we've just gone through it all, I thought.
But there's no rule that you must give a direction about inconsistencies will come up in a trial. There is no actual rule about that.
Well, there may not be a rule, but I thought we'd just gone through it and you've agreed that there were deficiencies, and you've agreed with the Court of Appeal on that.
I can't go against the Court of Appeal, in a sense, because I can see the reasonableness of the Court of Appeal having allowed themselves to agree with the appellant about certain of these discrepancies. I've understood that. But the fact that there has been discrepancies doesn't mean that the conviction should go, because, and here are two reasons. Even with the inconsistencies, there was a proper basis for this jury to convict of murder. That's an important submission that needs to be made, even if all of these inconsistencies, forgive me, and discrepancies were dealt with. And I come back to the overriding power and support and compellability for the identification evidence. Even with all of the inconsistencies in.
Isn't that an oxymoron, saying this is compellable evidence, but here are all the weaknesses?
My respectful submission is you can give a quality to the identification evidence and say that it's compelling, but when you put it all together, because you do have to look at the overall evidence, one feature of it will stand out amongst all the others. And therefore, that's why we choose to adopt the word from the Chief Justice. The identification evidence was compelling. There would still have been a conviction if everything else was right and every other issue put in its place.
Well, you have to say there would inevitably, don't you?
Yes, it would inevitably have been a choice for the jury to convict.
Well, inevitably a choice.
No,
Because
inevitably.
the test is it inevitable that regardless of all of the difficulties, the jury would have
Yes,
convicted?
yes, that's exactly what we say.
As you said, well,
The nature of this killing was and those who watched it and were able to give an account is another feature of the power of the identification witnesses.
Why?
Because it means there's less room for a mistake by them. Less room. They know who they see.
Well,
And
that's nothing to do with the nature of the killing, is it?
it's one way of looking at it, yes, because they're very close. They see who is the perpetrator, and they see how that man lost his life. So it is a feature for that jury.
well, another way of looking at it, Miss Weeks, is that somebody who sees something so horrific taking place before them may be concentrating on the person who's stabbed rather than anything else. I mean, it doesn't go one way or another. You yourself said one way of looking at it, and we've got to look at inevitability.
Yes?
Well, can it be inevitable if there's more than one way of looking at things?
We will still maintain our position that the quality of the identification will always, for a jury, overshadow the inconsistencies. I do want to touch upon the alibi because it does go into the mix.
Well, we're getting quite near the end of your time, and you've got two items to cover, I think.
I do.
We'll probably better give you as free a run as we can.
Okay, I'll come if I need to come back to any of those answers for that important topic. I can deal with the alibi relatively straightforward. It's correct on the facts that there was name and address given to the then DPP, and the name and address gave a very clear indication that the appellant, through his then lawyers, was going to call alibi evidence. We've already looked at the two documents, which is the letter with the name and the address, and we've also looked at the response. We add to that any lawyer who has followed instructions to give name and address is more than halfway to a decision with he and his client that they're going to call alibi evidence. The difficulty comes to where we are 11 months from the time and the date of the letter in August to the trial itself, which was no longer in 2003 but in 2004. Nothing at all happens to the alibi notice. There isn't any letter, there isn't any contact. It's very difficult if not impossible, for a court without specific evidence in affidavit form, preferably from the appellant, who would have been the inside person into what decisions were to be made about whether the alibi is called or not. We obviously accept the response from now the deceased attorney, who made it clear, I cannot help you one way or the other as to the reasons for nothing, as the reason for that the alibi wasn't called at the trial. If the appellant wants to rely upon the failure, which must be a deliberate failure, because you got the evidence that 2 alibi witnesses' names and addresses were sent, he needs to put proper evidence before this court. It's quite a serious allegation to say that an attorney who clearly took steps to act on behalf of a client, no doubt both teams, the defendant, appellant, and the attorneys, were all at one in August 2003 to give details of the alibi. We can guess, we can speculate. Did the lawyers unreasonably simply say, don't call? Did he say, well, I've changed my mind? Speculation and guesswork doesn't work.
We've got some evidence that Yvette says nobody ever asked her for a statement. How could they have assessed her evidence or made a proper decision without taking a statement?
One way of dealing with that is that you, certainly the best person about his communications with his solicitors, if they did not contact her, it is, we say, utterly surprising that there is nothing from the appellant, who must have had some communication with his lawyers at the beginning of the trial. You definitely want to have a chat about what witnesses you call. When you have given your evidence in the witness box and you spend all of your time talking about alibi, there is a conversation to be had with your lawyer. The authorities are very clear. You do need a proper basis and proper evidence before a court if you are going to suggest bad misconduct or a very bad, unreasonable decision. And it would be utterly unreasonable in a case where you've agreed that the name and address of the alibis are sent, and then for some reason they don't arrive at court. There must be proper evidence before this court, because that would be misconduct.
Well, there is evidence of misconduct, Miss Weeks, which the DPP accepted effectively in conceding that the appellant's mind did not go with any notice of abandonment, and that he had never given instructions to abandon his appeal, nor had he ever expressed remorse. So there is that evidence that we have now. We've also got an affidavit from Yvette, which actually indicates that when she went to court, she was not allowed to go inside the courtroom by the police officers.
May I deal with the first point that you raised, my lady? That is an affidavit that deals with the reopening of his appeal and the ruling that the Chief Justice made. It wouldn't be right and fair, I respectfully submit, to use that to say we have evidence that in relation to alibi there was a piece of misconduct by the lawyer. He did the best he could 8 to 16 years later with no files and no paper. He was unable to give any assistance about what the reason was. He was bound to have given the reason if he genuinely remembered it. The passage of time is and can be very damaging to lawyers. We say it wouldn't be right unfair to adopt what happened in relation to the issue of the abandoned trial, because it's in a wholly different part of it. He was able to write an affidavit in relation to that. Why do we not have an affidavit in relation to this serious allegation about his communication with his lawyers? We can all think of the pivotal points where a lawyer must speak to his client. If, for example, it's in the minds of any of our judges here that this lawyer must have just decided to say, don't call the alibi. Well, I'd like the appellant to have been able to address this court so we could have understood it. They've had plenty of time to do that, certainly since the appeal. Nothing has happened before and nothing has happened now. There are two examples of authorities within our bundles where the need for affidavit is required. And this is a case where affidavit evidence...
So what you're envisaging, just to be clear, is that, I mean, clearly there was no further affidavit evidence, or no affidavit evidence to be gained from the lawyers. For the
well, the lawyers have answered the best they could.
So what you're suggesting is that there should have been an affidavit from the appellant dealing with this?
Yes, we do.
Yes.
Because it is perfectly possible for him to be able to assist the court if he pursues with his legal team that it is the fault of the lawyers not to call his alibi. And we find it very difficult to think that a lawyer begins this process by giving date and name, and then all of a sudden he makes the decision not to. Things can change.
So you're saying that he should have said, well, I never gave instructions not to call the alibi witnesses, for example.
His answers have always been, I do not remember one way or the other.
What, the appellant?
The appellant's counsel.
No, I'm talking about the appellant.
Oh, we've had nothing from the appellant.
Right.
And we should. We should. It's only right, if you are going to deal with this allegation, that something should be put. It's now very late in the day for that to happen.
We need to hear from you, I think, also on good character briefly, don't we? Unless you're going to have it unloaded, Julia.
No, I can deal with both. Just on the alibi, I do have one point that may assist. The features of the alibi that concerned the Chief Justice was set out. I want to add another feature of it, which she had not mentioned at the time, but it was within the documents. If we turn to EB 99, it's a short point, but an important one that is relevant to what seems to be a conflict between the evidence given by the appellant and what is within the affidavit of Yvette Maynard. If we go to, I'll just get the number for you. You will see at the bottom of the page, forgive me, upon our arrival, this is when Officer Sutton, having begun his investigation of the murder, towards the 2 o'clock and thereafter, he arrives at number 2. Upon our arrival, accused number 2 was at home, but at the time we had information regarding his brother, Baldhead, who is known as Vincent Maynard. Having spoken to the accused, number 2, we left the yard. We've already had some contributions from some of my ladies and lordships about that. Yvette seemed not to have had that detail within her affidavit, but she must have been home at the time, but she doesn't give any evidence about why she didn't know he had left the house into the yard. Upon leaving the yard, I met Ballhead in the road, and he was taken into custody. Whilst speaking to Ballhead, when out the top of 100, line 5, at the station, he told me something. As a result, we returned to accused number 2 home, but he was not there. It could be that he legitimately had somewhere to go, and I know that in part of the history they had gone to visit a brother at some point. But here is another occasion where if Yvette is at home, she isn't given evidence of the content of her affidavit. He always tells me where he's going, and I can see that he's left the building.
But she said that after Baldhead was taken into custody, she and Nardis went to the police station. So that's why Nardis wasn't at home.
I don't know what time, my lady, that's the point.
I think this is real speculation.
Yeah, we just don't know what time it was, but I put that into the mix because it is important. His evidence at court was he doesn't go to look over the partition because there's a hole in the wall. If we can go to his evidence.
Well, what's all this going to? What's your point?
It's going to differences in his account and her account.
But those would have been points for the jury to weigh up when deciding.
They may well be, but I wanted to put them before the court because they're really fairly serious points that undermines the account she is going to give. And therefore, it is not a strong alibi. It's only a small point. I'd like to deal with it. It's EB 116. I just want to make sure I've got the right page. Just forgive me for one moment. I've lost my point on this. I'll get it in a moment.
Well, you are over your time.
I'll just be very quick. It's actually on 115. Forgive me. The clock is over the bed. There's a partition which divides our room. There is a hole in the partition. I could not peep over the partition. The only way I could see what is happening in the next room is through the hole. It is not possible for me to leave the room without Yvette knowing. She never mentioned a hole in the partition. It's a small but very important point. She talks about getting on the bed to look over the partition. He says there is a hole in the partition. And that's the evidence he gave to his jury. Perhaps I ought to turn to the...
Well, we may have to take it on what you said about it in your written case, because we have to give...
Yes, I think you can. I've set it out perfectly, I hope.
And we can't put beyond 4 o'clock.
Yeah, I think it's all there within what I've already said.
Good.
I hope. I'll just quickly see. Yeah. I can leave it there because it's within my response.
Thank you.
Thank you.
Ms. Gray.
Keeping with the identification evidence and the points that have been raised, if I could take the court to
page 416 of the electronic bundle. Any specific, and it's really set out in Turnbull, as has been referred to, that it's part of the skeleton argument at paragraph 46, page 416, and what Turnbull says about the failing to deal with specific weaknesses. Finally, the judge should remind the jury of any specific weaknesses which had appeared in the identification evidence. Then at page 417, a failure to follow these guidelines, so including failure to set out the specific weaknesses, is likely to result in a conviction being quashed, and will do so if in the judgment of this court on all the evidence the verdict is either unsatisfactory or unsafe. So Turnbull has made it very clear that specific weaknesses are fundamental in the context of identification evidence. Then if we look at electronic bundle page 418 and the reference there to the Patterson and Exley, paragraph 51, again 1996 case, going back to referencing R.V. Fergus, it's not good enough for a trial judge simply to refer the jury to counsel's submissions about specific witnesses in the identification. Under Turnbull, he must fairly and properly summarise for the jury the specific weaknesses as arguably are exposed by the evidence. The judge never came near to doing so. And then if we turn over to page 419, at paragraph 54, in Omar Greaves and others and the Queen, it's not sufficient merely to read to the jury the factors set out in Turnbull's case and at a later time to read to them the evidence of the witnesses. Now, in Nardis Maynard, this case, there was the general Turnbull followed by the summary of the prosecution witnesses. The jury have heard all of the evidence in the case when the witnesses testified. It will not assist them if the evidence is merely repeated to them. What they require from the judge in the final round is his assistance in identifying, applying, and assessing the evidence in relation to each direction of law which the judge is required to give them, and also in relation to the issues that arise for their determination. And then at page 420, paragraph 58, again, just a summary of what's set out in Blackstone's criminal practice. Paying lip service to the guidelines will not be enough, nor will it suffice to give a general warning without any reference to any evidence that may support or undermine the identification.
And is all that directly applicable in a recognition case?
Absolutely in a recognition case. Turnbull makes that plain, that it is in recognition as well as somebody who didn't know the assailant.
Well, it says in Blackstone, the applicability of the Turnbull guidelines to cases of alleged recognition is discussed at F 19.9. I don't think we've got 19.9.
I looked at it, it does say it applies.
Yeah,
You should have a look at it. Yes.
I mean, it may be that the answer is,
19.
over the course of time, it's become accepted that the same approach applies, but I'm not sure we can find that in Turnbull itself, but I may be wrong about that.
I think you're right.
I mean, there are significant, specific weaknesses that have been highlighted in the skeleton argument, which, you know, the difference in this case, and we've made the point, is that the Court of Appeal tended to say, well, certain weaknesses weren't highlighted. The point we made was this summing up was devoid of any balance, devoid of any identification of a single specific weakness. It amounted to the general Turnbull direction, followed by a summary of the prosecution evidence, and the judge reminding the jury that there were 3 people who recognised the assailant as Nardis Maynard, when in fact, and I began the submissions this morning, that can't be correct, because of course Jason Hamilton is in a different category to Kamisha Powell and to Marilyn Lowry in what he identified of the assailant. Moreover, the general rule, this is F19, F19.3 in Blackstone's. F19. It's at the top. The general rule, therefore, is that an appropriate Turnbull warning should be given, even in cases of alleged recognition.
Well, that's not saying it's exactly the same as Turnbull, is it? That would imply that it's something less, potentially. But look, I didn't want to derail you now. It may be that if you want to put anything in, that would be helpful. But your submission is, over the course of time, it's effectively become one and the same. That is, that recognition cases should more or less be treated in the same way as identification cases.
Yes, and that in this particular case, not a single, there was no balance, there was no even stretch of a balance. The most that the judge did at trial was to say, well, Nardis Maynard told you he was at home. Nardis Maynard told you that he wasn't involved in the crime. But there was no check, there was no assessment, there was no standing back and weighing up the reliability, the accuracy of the witness's evidence as far as identification was put forward. As to simply summarise the prosecution evidence is simply not enough. None of those opportunities to headline and to assess the weaknesses were given to the jury whatsoever, and it's that failure to create any balance. And this is a case where there are a number of prosecution witnesses who were identifying Nardis Maynard, yet that balance wasn't created. Just dealing with the I just go back to Omar Greaves on page 419. In relation to the alibi evidence, it's important to recognise that Yvette Maynard's statement was really dealing, what alibi witnesses do is deal with the time, the specific time between 12 and 1 a.m. in the morning. That's what her statement was dealing with, where was her brother at that time? There's been what we call perhaps a distraction in that, well, she's not been referring to, she didn't mention her brother being out in the yard, and she didn't mention that in her witness statement. Her brother being out in the yard was hours after the critical time. The critical time was between 12 and 1 a.m., and that is what the alibi statement is dealing with. We know from Sutton, PC Sutton, the officer in the case, the length of time it took to get to the Maynard's home address, because, of course, from 2 a.m., he's gone to the hospital. Then he's gone to Ingle Rawlins' house. Then they go back to the police station. Then they go to the Maynard house. So this is, you can imagine this significant period of time after they arrive at the Maynard household. So it's important to recognise when the alibi witness is talking about in relation to it's between 12 and 1 a.m. rather than hours later. Just in dealing with, there is reference to just dealing with the search warrant. There was a question asked in relation to what clothing did the police ever, when they went to the house, did they ever find anything at the house, at Maynard's house?
I've got the page that you're going to take us to, I think, which is the evidence of the officer at Electronic Bundle 75.
Sorry, what page?
75. He's asked what he was wearing. He said, I'm wearing the pants and the shoes, but the shirt is at home. Let's go for the shirt. Other police officers and I accompanied him to his home, where he took off and handed over to me his grey short pants, a grey shirt and plaid boxer shorts and a pair of slappers, which I think are the shoes.
Sandals, yes.
Yeah.
Those were the items that the appellant was wearing that night, and those were the items that the appellant was wearing, and those were the items that were forensically tested and came back as negative. It's the search warrant at page 10 of the bundle. This is the search warrant in relation to the home address, and it's page 10, at the top of page 10, the handwritten, duly executed the warrant within the named premises, in their absence but in the presence of Maynard. Nothing was found. That was at 10:50 in the morning on the 22nd of March. So the incident occurred in the early hours of the 22nd, the Saturday morning. And then, of course, the police come round that morning. By that stage, Vincent Maynard is in the police station. At that stage, Nardis Maynard is not a suspect. And so there is a search, obviously, of the property. And nothing of significance is found. Excuse me. We say that in relation to the proviso, that we rely on the case of Cassell, which we have set out in the skeleton argument. And it's at page 433, Cassell and another and the Queen.
That was a case about directions on dishonesty, not identity.
Yes, it's the point that it's Lord Hughes's statement in relation to...
The more minor the errors.
I'm so sorry.
Sorry, no, carry on.
In relation to the more defects, the more clearly, the more impact that would have on the verdict. And so here we have set out, and this is really dealing with the identification point, but really here we have set out the list of factors that we say the judge should have identified to the jury. We say this case really, things went wrong from a very early stage in this case, and that the failure to call the alibi witnesses, failure to correct the judge in relation to any specific weaknesses, and the failure of the judge to identify those weaknesses, the failure to give the two-limb direction in relation to character, when in this case, effectively, that's all the defendant had, his character, his credibility, the fact that the propensity direction, not somebody who committed any offences in the past, and so bear that in mind, his credibility when it came to judging what he was saying to the jury. That's all he had, and again, that's something that went wrong here as well. Coupled with, of course, what happened later at the appellate court. So we submit that there were significant defects that would have impacted on the verdict. And in our respectful submission, there has been clearly a miscarriage of justice in this case.
Well, thank you very much, both counsel and indeed junior counsel for the appellants, for your oral submissions, and all counsel for their excellent written cases. And we would extend those thanks to those in the team behind them who have no doubt contributed to the presentation of a concise and helpful set of submissions on a actually quite detailed case. The board will take to consider what advice they humbly tender to His Majesty